Hey, what's up, everybody? This is Isaac from Guns for Everyone. We're going to talk about the secure storage laws for firearms in the state of Colorado. And the way I'm going to format this video is I'm going to quickly read through the law, and then I'm going to provide some commentary on some interpretation of the law, and then maybe at the end I'll include how much I hate this. But for the sake of those who are looking for this information, let's start with what the law says. So first of all, let me tell you what law we're talking about. You're going to look for the Colorado Revised Statute, CRS 1812114, and you can get there by going to lexisnexis.com/hot-topics/Colorado. I will put a link in the description, or you can also just Google Colorado Revised Statutes and follow the first link that comes up in the results. Click the buttons until you get to the CRS. 18-12-114. I'm going to read it real quick. Part 1. Firearms must be responsibly and securely stored when they are not in use to prevent access by unsupervised juveniles and other unauthorized users. A person responsibly and securely stores a firearm when A. The person carries the firearm on his or her person within such close proximity thereto that the person can readily retrieve and use the firearm as if the person carried the firearm on his or her person. B. The firearm is kept in a locked safe or other secure container or in a manner that a reasonable person would believe to be secure, and a juvenile or resident of the premises who is ineligible to possess a firearm does not have access to the key, combination, or other unlocking mechanism necessary to open the safe or container. C. The person improperly installs a locking device on the firearm, and a juvenile or resident of the premises who is ineligible to possess a firearm does not have access to the key, combination, or other unlocking mechanism necessary to remove the locking device. Or D. The firearm is a personalized firearm and the safety characteristics of the firearm are activated. Okay, Part 2. A person commits unlawful storage of a firearm when the person fails to responsibly and securely store a firearm as described in subsection 1 of this section upon any premises that the person owns or controls, and the person knows or reasonably should know that, number 1, a juvenile can gain access to the firearm without the permission of the juvenile's parent or guardian, or 2, the resident of the premises is ineligible to possess a firearm pursuant to the state or federal law. B. Unlawful storage of a firearm is a Class 2 misdemeanor. C. It is an affirmative defense to the offense of unlawful storage of a firearm that a juvenile gain possession of and use the firearm for the protection of or exercising the rights contained in Section 18-1704 or 18-1704.5 or in defense of livestock. Part 3, this section does not apply to storing an antique firearm as defined in 18 U.S. Code Section 921A16 as amended, or a curio or relic as defined in 27 CFR 478.11 as amended. Okay, that's secure firearm storage. Let's quickly run through the new law for secure firearm storage in a vehicle, which is 18-12-114.5. And this goes into effect July 1st, 2025. That's the first note on the revised statute. 1A, this section is effective January 1st, 2025. A person shall not knowingly leave a handgun in an unattended vehicle unless the handgun is in a locked, hard-sided container that is placed out of plain view, including a locked container that is permanently affixed to the vehicle's interior, and the container is in any of the following: a locked vehicle, the locked trunk of a locked vehicle, or a locked recreational vehicle as defined in 2432-902. A person shall not knowingly leave a firearm that is not a handgun in an unattended vehicle, this is Part B, unless the firearm is in a locked hard-sided or locked soft-sided container, including a locked container that is permanently affixed to the vehicle's interior, and the container is in any of the following: 1, a locked vehicle, 2, a locked trunk of a locked vehicle, or 3, a locked recreational vehicle defined in section 2432-902. C, A firearm that is not a handgun that is stored in a soft-sided container must have a locking device installed on the firearm while the firearm is stored in the soft-sided container. D, for the purposes of this subsection, 1, a locked glove compartment or the locked center console of a vehicle is a locked hard-sided container. Part 2, a person who violates subsection 1 of this section commits unlawful storage of a firearm in a vehicle, and unlawful storage of a firearm in a vehicle is a civil infraction. This section does not apply to storing an antique firearm, same as the last one, defined under the United States Code. B, storing a firearm that is not a handgun in a vehicle that is being used for farm or ranch operations that is on the person's private farm or ranch, including a leased farm or ranch. There's definitions of farm and ranch. C, a person who lives in a vehicle or a recreational vehicle as defined in 2432-902 in which the firearm is stored. So homeless, living in a vehicle, or as they call it these days, adventuring. A person who lives in a vehicle or recreational vehicle must store firearms in the vehicle or recreational vehicle in accordance with 1812-114. D, does not apply to a peace officer. E, a person who holds a valid resident or out-of-state hunting license who is engaged in lawful hunting activities. F, a person who engaged in the instruction of hunter ed courses and outreach offered by the Division of Parks and Wildlife. And G, an active member of the United States Armed Forces while on duty. Number 4, notwithstanding the requirement in subsection 1 of this section to store a firearm in a locked, hard-sided container, a person who is considered to have a disability, as defined in 42 U.S. Code section 12102, who stores a firearm in a locked, soft-sided container does not violate this section with respect to the storage of that firearm that is in the locked, soft-sided container. And 5, as used in this section, unless the context otherwise requires, vehicle has the same meaning set forth in section 42-102. And I'm going to quickly list off what is listed in there. A bicycle is a vehicle, an e-bike is a vehicle, an e-scooter is a vehicle, and an EPA-MD, which I did not look that up. What is not a vehicle? A wheelchair, an off-highway vehicle, a snowmobile, a farm tractor, or vehicles that are primarily intended for travel through the air. All right, so I've done my part. I read the laws. Now let's backtrack and go over what they mean. Okay, so we're going back to 1812-114, secure firearm storage. Firearms must be responsibly and securely stored. Okay, let's talk really quickly about rights and responsibilities. You do have a responsibility to secure your firearm from unauthorized access. As a gun owner, rights come with responsibilities. And if you fail to meet those responsibilities, the risks are that the rights go away. So, there are political reasons why gun laws have passed in this state, but there are practical reasons too. And most guns used in crimes are stolen. And a lot of guns are stolen from unsecured positions in vehicles, especially guns left in vehicles unnecessarily. So you do have a responsibility. That is true. Securely stored when they are not in use to prevent access by unsupervised juveniles and other unauthorized users. A person responsibly and securely stores firearms when A, the person carries the firearm, holster, on his or her person within such close proximity thereto that the person can readily retrieve and use the firearm as if the person carried the firearm on his or her person. So it's talking about close proximity here, and I think that there is an argument here to talk about storing a firearm securely, meeting the definition of secure according to the law, leaving a gun on a nightstand while you're sleeping. I'm not saying that you should do that. But the question does come up occasionally in classes, what if I put it on or in the nightstand while I'm sleeping? Well, within such close proximity thereto that the person can readily retrieve and use the firearm as if the person carried the firearm on his or her person. So the argument is there. I'm not saying you would win the argument. I'm saying I think you could make the argument. Now, what we talk about in our firearm classes is that if you are staging a gun for use, it should be staged securely and available for quick access. So something like this Vaultec case that has a biometric fingerprint reader on it, and putting that on the nightstand or in the nightstand. But I'm just trying to talk through the strict definition of the law here. B, the firearm is kept in a locked safe or other secure container. So other secure container means, so a locked safe, it says locked gun safe. The Vaultec, among many, many others, is marketed and sold as a firearm storage device, and it locks. So that meets the definition, locked gun safe. It says, or other secure container. So grab your Pelican case and throw a padlock on it. It's a container, and by any definition, we'd say put the padlock on it. It is now a secure container. Or in a manner that a reasonable person would believe to be secure. So my office has a lock on the door that requires a key. You can't open it with a screwdriver or a penny or anything like that. It requires a key. So if the door is locked and the key is secure, then I think you got a good argument that a reasonable person would believe to be secure would be the entire room. Anything within the room, there's a reasonable belief of security there. Now, any law can be defeated. So if you take the absurd argument and say, well, if I had a handsaw or a bandsaw, if I just kick the door hard enough, it's not secure anymore, there are limits to what is required on your end. And a locking door with a key, I think you've got a strong argument that that is a reasonable belief of security. Okay, let's continue. And a juvenile or resident of the premises who is ineligible to possess a firearm does not have access to the key. So the qualifier here is that there is a juvenile or resident of the premises who isn't eligible to possess a firearm. So if you don't have these people in the home, I think the reading of this is that there is no legal requirement to store the firearms inside the home any more securely than locking the doors in and out of the home. Now, I don't have an attorney who's said that, and I don't know of any cases in Colorado where that question has come up. But the way I read this is the secure storage requires the presence, or the need for the secure storage requires the presence of a juvenile or a ineligible person. And your ineligible person is going to be somebody on parole with weapons restrictions, probation with weapons restrictions, pretrial release with weapons restrictions, or is a convicted felon and not permitted to handle firearms. Okay. So that juvenile or ineligible person does not have access to the key, combination, or other unlocking mechanism necessary to open the safe or container. So you can live with these people and you can own firearms, but according to the law, you must secure them from their access. C, the person properly installs a locking device on the firearm, and a juvenile or resident does not have access to the key, combination, or other unlocking mechanism necessary to remove the locking device. So this is your cable lock, your gun locks, your trigger locks, things like that. Things that are marketed and sold as firearm security devices. And then part 4 here is relevant to a very small subsection, and that is the firearm is a personalized firearm and the safety characteristics of the firearm are activated. This is your biometric handgun, and there aren't that many of these on out in the wild these days. But if you had a gun with a biometric safety device on the gun and the device is activated, then that meets the definition. Part 2 is interesting, and I want to get into this just for a second. A person commits unlawful storage of a firearm when the person fails to responsibly and securely store a firearm as described upon any premises that the person owns or controls, and the person knows or reasonably should know that a juvenile can gain access to the firearm, a resident of the premises is ineligible to possess a firearm pursuant to the state or federal law. So we're reinforcing the idea that if you don't have these people living in your house, you don't need to do any extra firearm security. But this is interesting. A juvenile can gain access to the firearm without the permission of the juvenile's parent or guardian. So what if you have a juvenile that has permission to access firearms? The way I read this, that means that with the juvenile in the home, as long as they have permission to access firearms, you do not have to secure them from those juveniles. Now, again, I'm not an attorney. I did bring this up with our attorney, Brian DeBush, and he said, that's very interesting, and that's all he said. So, again, I don't know of any cases where this has been tried. And the reason I bring this up, because there are people out there who've got the 17-year-old in the house who may want to leave access for the gun for hunting purposes, for sporting purposes, something like that. B, unlawful storage of a firearm is a Class 2 misdemeanor. So in any property that you own or control, your house, rental properties, businesses, hotel rooms, things like that, it is a Class 2 misdemeanor to leave the firearm unsecured from the juvenile without permission or the ineligible person. And C, it is an affirmative defense to the offense of unlawful storage of a firearm that a juvenile gained possession of and used the firearm for the purpose of exercising the rights contained in Section 18-1704 or 18-1704.5 or in defense of livestock. 18-1704, use of lethal force in defense of a person. 18-1704.5, defense against intruder. So here's your situation where the juvenile used a firearm to protect people or protect themselves within the dwelling. So when it says it's an affirmative defense, that means I did the illegal thing, but I had a legal reason why it was lawful in this specific case. And then finally, this does not apply to antiques or curios and relics. So if you've got a firearm that was built before a certain year, and I forget off the top of my head what year that was, I think it's 1968, or meets the definition of a curio and relic, then those firearms do not need to be secured under this law. Okay, that's what the law says. A gun that is capable of causing harm should be properly secured. Whatever that means, if it's quick access for use for self-defense or storage of the firearm when not in use. So you've got your hunting rifles or your collectibles or things like that, guns that are not intended for self-defense, not staged for self-defense. Those responsible gun owners put those things in areas where they are secure. Gun safe, locking room, cable locks, something that secures that gun away from harming other people who shouldn't have access to those guns. Okay. So, I think I beat that one to death, so let's talk about the 1812-114.5, secure firearm storage in a vehicle. So, again, this goes into effect January 1st, 2025. A person shall not knowingly leave a handgun. So this first part applies to handguns only. Colorado's definition of a handgun, a firearm with a barrel of less than 12 inches. Shall not knowingly leave a handgun in an unattended vehicle unless the vehicle is in a locked, hard-sided container that is placed out of plain view. This is a locked, hard-sided container that I can place out of plain view, including a locked container that is permanently affixed to the vehicle's interior. And we're going to jump ahead to the part where it does include glove compartments, locked glove compartments, or locked center consoles of a vehicle. And the container is in any of the following: a locked vehicle, the locked trunk of a locked vehicle, or a locked recreational vehicle as defined in 2432-902. Okay, so let's kind of go through this slowly. Handgun in an unattended vehicle. So that means if you're in the vehicle, none of this applies. If you're in control of the firearm in the vehicle, none of this applies. You can drive around with your gun in your holster. You can drive around with the gun unsecured, which you shouldn't do, but the law does not prohibit it. Okay, so unattended vehicle. Unless the handgun is in a locked, hard-sided container that is placed out of plain view, including locked container permanently affixed to the vehicle's interior, and the container is in any of the following. So the strict definition reading of this law is that this container does not need to be permanently attached to the car. You don't need to cable lock this thing into the car. Just placing it under the seat or out of plain view does count. That's not a good practice when it comes to securing firearms in cars. So if you just toss this whole thing into the car and then throw a blanket over it, the person who breaks into that car can now just take the entire container with them. that doesn't, in my view, meet the definition of securely securing a gun inside of a vehicle, but the law says it does. Okay, and the container is in a locked vehicle, the locked trunk of a locked vehicle, or locked recreational vehicle. So we lock it up in the case, throw it under the seat, throw a blanket over it, and lock the car. You do not meet the definition of the law if the car is not locked. All right, let's go a little further. A person shall not knowingly leave a firearm that is not a handgun in an unattended vehicle unless the firearm. So now we're not talking about handguns. We're talking about the Colorado definition of rifles and shotguns. In an unattended vehicle unless the firearm is in a locked hard-sided or locked soft-sided container. So your rifle bag with a lock on it, including a locked container that is permanently affixed to the vehicle's interior, and the container is in a locked vehicle, locked trunk, or locked recreational vehicle. In addition to that, Part C says a firearm that is not a handgun that is stored in a soft-sided container must have a locking device installed on the firearm while the firearm is stored in the soft-sided container. So you need to lock the soft-sided container, and you need to have a cable lock or trigger lock or some other reasonable means of locking the firearm itself. I say some other reasonable means. There is, I really hope this guy doesn't watch this video because he's going to be mad I forgot his name and I didn't prepare and come up with it beforehand. But there is a guy in Colorado who's making AR-15 grips that have a keyed lock on the grip that the safety device will not disengage on the gun if the grip is locked. And so that would be a locking device on the firearm. That would meet the definition. All right, D. For the purposes of this subsection, a locked glove compartment or locked center console is a locked hard-sided container. Does count. Now, again, going back to what is a good idea, it doesn't take hardly any effort at all to break it into a locked glove box. It meets the definition. It doesn't, generally speaking, work as far as actually securing a gun from unauthorized use. Part 2. A person who violates the subsection of 1 of this section commits unlawful storage of a firearm in a vehicle, and that is a civil infraction. So unlike the storage in the home or other location in the vehicle, this is a fine, not a criminal offense. This section does not apply to antiques, farm operators. So if you're riding around in the tractor and you got that gun hanging from the gun rack on the tractor, I guess, and you're on your farm, private farm or ranch, then it doesn't apply. If you live in your vehicle or you are using a recreational vehicle as a living space in which the firearm is stored, and if that is the case, then you default back to 1812-114. If you're a cop, you don't have to secure your guns. And a person who so holds a valid valid resident or out-of-state hunting license who is engaged in lawful hunting activities, and this commonly happens, you'll be driving around and you're keeping the gun ready for use for hunting, but you have left the vehicle. Again, I don't know why you wouldn't want to secure your firearm if you're leaving your gun unattended in your vehicle, but that's what the law says. A person engaged in the instruction of hunter ed, and this is specifically within the Division of Parks and Wildlife, so it's not you're just teaching somebody how to hunt. You have to be a sanctioned education course. Or active duty, U.S. Armed Forces while on duty. Disability, so basically you don't have to use a hard-sided case if your disability prohibits it. You can use a soft-sided case. I'm not really sure. I don't have enough industry knowledge to know how a soft-sided container helps with disabilities where a hard-sided one doesn't, but it's right there in the law. And then gives the definition of vehicle. So leaving a gun on a vehicle, that means a vehicle is a means a device that is capable of moving itself or of being moved from place to place upon wheels or endless tracks, and includes bicycle, electric assisted bicycle, electric scooter, or EPA MD. So this includes motorcycles, but does not include a wheelchair or off-highway vehicle, snowmobile, farm tractor, or implement of husbandry, designed primarily for agricultural operations. All right. So I've already kind of interlaced responsible gun practices, responsible gun owner practices around this, but I want to emphasize, do not leave firearms in vehicles unnecessarily. Let me give you an example where it might be necessary. You cannot take a gun onto postal property, but you drive around town with your firearm and you have to stop at the post office. Is it a reasonable need to leave the gun in the car in order to go into the post office? I think a normal person would say absolutely. So then secure your firearm in the car when you go into the post office. Secure it in a manner where it is not easily stolen. So put it in something like this that is actually anchored to the car. It does get a little expensive, but you can work your way up. Start with something easy. Get one of those Amazon steel clamshell ones with the key lock on it, 20, 25 bucks, and cable lock it to the seat on the car. As you get better finances, maybe you can upgrade that to a quick access safe that's bolted to the car. Leaving the gun in your car in the driveway overnight because that's your truck gun. No, I don't think that's reasonable unless the gun is secure within the car with a very robust security device. They make vaults that fit under the back seat of trucks. They make storage devices that are fairly secure, but they're expensive. And I see a lot of people who are just, they'll hide the rifle somewhere in the car. This is my truck gun. That doesn't make any sense to me. Leaving the gun in the car where it's easily accessible to a thief. No, it's not your fault that somebody broke into your car, but you making it easy on them doesn't make you a responsible gun owner. So don't leave guns in cars unnecessarily. And when you must leave a gun in a car, make sure it is actually secure. I don't agree with these laws. I don't agree with almost really any laws. However, understand what the risk and benefit is of leaving guns in cars and how to do that responsibly and when you need to do that, and understand the risk and benefit around following these laws. So questions, you can put them in the comments section and I will do my best to answer them. Thank you for watching. If you made it this far, I know 27 minutes is a long time, but the more complicated the laws get, the more difficult it gets. So I hope I was using your time well. Check us out at gunsforeveryone.com. See the links below in the description. And I appreciate it, and I'll do more gun law questions in the future. All right, peace out.